Great to have you. Join me on another edition of Law and You, a program that comes every Monday at this time, looking at the need to throw light into some concepts that you may see as gray. And today we are considering the topic, ASUU strike. The federal government no work, no pay rule or policy is a very boiling one that a lot of Nigerians are really inching closely to understand what the committee set up by the federal government will come out with. Discussing this with me, looking at the legal implication, is a custodian of the law, a legal practitioner, Sunday Daudu. Thanks for joining me, Sunday.
Thank you very much, and thank you, viewers out there.
My name is Philip Omo-Gyupon. We'll take a short break. Welcome back. I did say we're going to be looking at the topic before us, which is on the federal government and ASUU strike, looking at the no work, no pay rule or policy. But let's look at this aspect. Looking at what we have at present, the federal government is backing out of going into more negotiations with ASUU. And at present is saying that it has increased the salaries of the lecturers, generally at the university workforce, to 23.5%, and also jacking up that of the professional cadre to 35%, and asking that there should be no account, they would continue the strike, otherwise the no work and no pay policy will apply. Is the no work, no pay policy legal to law?
Yes, to put the answer closely, there is a section of the Trade Dispute Act, particularly section 43, that recognizes the no work, no pay rule as it affects labor, employment, and productivity. So the provisions is there. But the question is, at what point do you resort to the implementation of that provisions of the law? I will give a background, but before going to that background, the posture or the government in respect to ASUU, that the salaries of ASUU with hair since March to date will not be paid, and that is what is meant by no work, no pay rule.
Oh, from February?
From February.
Yeah.
That is what is meant by no work, no pay rule. Is a misinterpretation of the provisions of the law. And as such, the opportunity have not been afforded to resort to that provisions of the law, to implement no work, no pay rule. It's there. But the question that is, at what point do you resort to it? Now, when there is a trade dispute between workers and employers here may mean government or institutions or other establishments or organizations, and workers who may be employees or other workmen for the purpose of defining who a worker is or who an employee is, under the Trade Dispute Act or under the Employees Compensation Act. So the distinctions are contained therein. Now the question is that when there is a strike action between government or employers now, and employees, but for this purpose, let me say government and ASUU, so that we can properly situate it.
Rightly.
Yes. When there is a trade dispute between government and ASUU, the question therein is, what is the basis of the industrial action? What is the basis of the dispute? It's from there you now be able to canvass whether or not the government can resort to the rules of no work, no pay rule as contained in section 43. Now, the current strike by ASUU, so-called strike, is not a strike stricto sensu. It is a strike regarded succinctly as protest strike. And what is protest strike? Protest strike is deployed by ASUU where the government has failed to honor a collective agreement reached. Now, the protest is aimed at enforcing the provisions of the agreement to which the government has failed to implement. Now, what then is this collective agreement that ASUU is protesting from February 14th? The collective agreement was a memorandum of understanding signed by government and ASUU to implement certain demands already signed. So once you sign that agreement, if you look at Section 9, Subsection 6 of the Labour Act, once a memorandum of agreement is signed between government and ASUU, it becomes binding. It becomes binding on both parties, that is both ASUU and government. So the question now that if government fails to implement the provisions of the memorandum of understanding, also the memorandum of action signed in 2020, the question now is that can they now resort to no work, no pay rule if they have on themselves failed to honor an agreement signed? They have to play their role. The part of ASUU was to suspend the action, the industrial action, in 2020, which they did. Now the federal government was to go and implement, which they said the implementation will start from January 1st, 2021. The question now is that ASUU have performed their own part of the bargain, suspend the action, which they suspended in 2020. Government start implementation in 2021 January. Government has failed from 2021 January to 2022 February. Now the same government who fails to implement the provisions of the law, or the act, or the agreement, now say they want to implement the no work, no pay. The question now is that can you benefit from your own wrong?
Okay, we understand the government is a continuum, and we also understand again that at the point where this agreement was made, it was not made under the government of Buhari. Now, when you made mention,
that is not correct.
When you made mention of, you explained, you throw light in that area.
Okay.
When you made mention of a strike action that is like that of a protest, you called it protest strike. Now, does the provision of the law carry the content that when there is such a strike action that is coming from the background of the refusal of government to attend to agreements signed with the union or the striking body, then such body could enjoy the largesse of getting their salaries paid for that period of strike? Does a provision say that? If it doesn't, then where lies your explanation?
Let me refer you quickly to the court decision, Enugu Court of Appeal decision, in the case of Union Bank of Nigeria versus Mrs. Edet, the Court of Appeal speaking. He said when there is a breach of enforcing the provision or implementing the provisions of an agreement collectively reached or collective agreement, the only instrument to implement or to enforce this implementation is strike action.
Okay, so you are looking at incidents.
Yes.
Because one thing is to have the provision of the law saying this.
Yes.
Another is to look at the incidents, yes, to also throw more light into the provision of the law.
Yes.
Okay, go ahead.
Now, if you now look at the provisions of Section 48 of the Trade Disputes Act, strike action was defined to include strike itself, that is full-blown strike, partial strike, protest strike, solidarity strike, work to no rule, go slow work.
Wow.
Lockouts.
We have different kinds of strikes.
Different kinds of strike. And the question is that for you to situate at what point, that's why I asked the question, at what point do you implement the no work, no pay? I will go to them.
Okay.
What they are currently in between February 14th to 31st of July was protest strike, not strike.
Not strike.
Sucho said so that we enable the government to implement the no work, no pay rule. Because at that point, opportunities afforded the government to quickly set up what they call dispute settlement mechanisms to arrest the situation, which also in the first instance gives a room of 90 days when you look at the steps, although each step has about 7 days to maximum 21 days, but the combination is 90 days to which the issue should be amicably resolved between parties. While that amicable resolution is ongoing, you do not suspend the payment of salaries of workers. Now, when all of this method fails, it really work, you go to Form TD3. You go to Form TD3.
Okay.
And now properly declare a strike action, which was done from 1st of August.
Okay.
That was when the strike action started.
Okay, you are trying to differentiate a protest strike from
the strike
a strike.
action.
Okay.
The strike action formally took effect from 1st of August.
Okay, what's the basic feature that differentiates a protest strike from a strike?
The protest strike was a strike telling government, look, implement the agreement already signed, which is binding on both of us.
Okay.
Please try and implement. Give you 1 day, 2 days, or 1 week, or a month. If you look at ASUU position, they gave 1 month in the first instance. Government, please do this within 1 month. The government didn't do that. Instead of quickly doing it, they suspended payment from that month. And the same government who says they were not aware of strike suspend payment of salaries without exhausting the opportunity of amicable resolution of the matter. Now, ASUU people are wise. What they did was to just continually give the government a leeway to ensure the implementation of the act. It was when they failed that ASUU now met and declared a full-blown strike from 1st of August. So from 1st of August, you can now rightly say that ASUU is on strike. So it means that the salaries of workers...
At the point where they now said indefinitely.
Yes, it becomes a strike action,
okay,
which now declared a full-blown dispute between government and ASUU. So at that point also, the government still have a role to play, the minister. That is why if you see like, I'm sorry to say that those who look at the implementations of law and all of that, they also look at those persons who saddle with the responsibilities. The only minister saddled with the responsibilities of resolving a dispute between government and ASUU is the Minister of Labour. But unfortunately, it was pushed aside as a Minister of Education to handle that. Because if you look at the definition section or the interpretation section, Order 48, the minister that is referred to in those definitions is the minister in charge of labor and welfare. And it's only the Minister of Labour that has the capacity. It therefore means that if you want to look at the legality, if a decision is even reached now, and it's reached under the auspices or the supervision of the Minister of Education, it may also be a subject of argument as to whether or not he has the capacity under the law to also be the one to midwife the resolution between ASUU
and the government.
All of these are put aside when looking at what the law says. The government doesn't even look at all these things. Whether the Minister of Education is capable under the law to act on behalf of the government in response to labor matters and welfare. He may as well be a member of a committee set up to resolve issue because ASUU is directly under its purview, academics. So it's Minister of Education. But we're talking about issue of labor, issue of condition of service, terms of and condition of work. The question is that even the reference to the Minister of Education for the purpose of midwifery or supervising the resolution may also be technically wrong. But that is not what we are going to. The question is whether or not the government at this point can implement the no work, no payroll. The answer is no.
Okay.
I will go further. Now that the ASUU have formally declared strike action from 1st of August 2022 and regard this as indefinite, the minister still have the opportunity to apprehend it. Whose minister? The Minister of Labour. What does he do? He quickly refers the matter to the Industrial Arbitration Tribunal.
Okay.
There are provisions there. If, for instance, the process of mediation, conciliator have failed, you probably seize the matter and decide who you refer the matter to. You refer it quickly to, because if you look at the panel set up, they've already made recommendations set up by the government, wherein they argue that the minister, professor should be paid 1.2 million, get about down the ladder. Now, there are opportunity provided when that committee report is submitted to the minister. Which minister now again is Minister of Labour. And the Minister of Labour has several days within the law to disclose the award. The committee cannot disclose the award. It is only the minister. This is what the committee arrives at. They now give room for both parties to object to it or accept it. Now, let me concede that it was submitted to the Minister of Labour. It was disclosed to both parties. Because if you consistently hear that Labour, ASUU will say they were not carried out, it's only a newspaper. Not that a meeting was now called and say, this is what the committee recommends. ASUU, do you agree? Government, do you agree? That has not been. I can tell you without mincing words that has not been.
Okay, so in that case, when can we say that a strike is illegal? looking at what you've just stretched out now, you made mention of the protest strike that culminates into the strike.
Yes.
You know, like ASUU that began his strike at August 1. Now, you also made mention of in a position where the federal government and ASUU are not able to amicably resolve the issue, then it's referred to the industrial court, you said?
Industrial arbitration
tribunal. Now, is it from that point we can now say that the strike is illegal if after the arbitration tribunal, gives a verdict and is still being disobeyed by the union?
No.
Or at what point can we say that it's illegal?
No. Now, if you look at other section 8 of the Trade Dispute Act, when an arbitration tribunal, industrial arbitration tribunal, gives an award, and the minister has disclosed it to both government and ASUU, for instance, and one party objects. For instance, the person objecting now, if we must play with government objecting to what the committee recommends. He said he cannot pay what the committee recommends. Now it is government that objects. The minister still have the opportunity of referring the matter to the National Industrial Court. Now, once the National Industrial Court...
National Industrial Court.
Yes.
This is a whole long process.
It's a long process.
And during this period, the strike is still on.
Yeah, so once...
Shouldn't there be a law that would...
I will get to that.
Okay. Why that is going on, they can suspend the strike?
Yes, I will go to that.
Okay.
Now, once the matter from the National Arbitration Tribunal is now referred to the National Industrial Court, the decision given by the National Industrial Court is final and binding at that stage. This option has not been explored by government because they are the one who objected to what the committee recommended and not ASUU. They objected. And when you object, there is a room for quick resolution, which government did not immediately do. Because when you object, you give an opportunity to say, okay, I object to 1.2 million, for instance, for professors. I agree on 1 million, for instance. Then if it is now ASUU that objects, then the master now goes to the National Industrial Court. Once the National Industrial Court gives a verdict, so because the National Industrial Court will now look at the position of ASUU and the position of government. And give a harmonious or a consensus.
Without sentiments.
Without sentiments, evaluate both sides of the and give a decision.
So that appears to be where it's going towards.
Yes, once he gives a decision, that decision becomes binding and not appealable, except of course it can only be appealed if the fundamental human rights of citizens or of the workers is affected. If it is not affected, it becomes binding and final, of which there is no appeal. At that stage, if ASUU still consists or persists in the strike, it is illegal. And the law also says that an offense has been committed.
Okay, at that stage.
At that stage,
okay,
it becomes illegal.
Okay.
And the provisions of the law further says that an offense has actually been committed. And if convicted, if it's an individual, you pay 200 naira for each day. You pay 200 naira in the first instance. If you continue after the period, for each day that the offense succeeds, that is strike succeeds, you will be paid to 200 naira another. But if it's an organization like ASUU now, no, not an individual now, ASUU, they will pay 2,000.
Okay.
And each day the offense consists, which is continue remaining in strike, then of course you continue to pay, it becomes illegal of strike action. Okay. And if you look at the section 18 again, it is at that point that section 18 make strike illegal. There is section 18 of the law.
Okay, where it made strike illegal. Okay.
It is at the point where all of these procedure, amicable resolution, industrial action,
which has not been exhausted.
No, it has not been exhausted. When those things have been exhausted, then you remain perpetuity on strike.
Okay, so which means the no work, no pay shouldn't apply now.
No, it shouldn't. It doesn't even
until all these avenues are exhausted.
Now, if they persist, the government has option, which are called the two theories of strike. One is the repudiatory theory of strike, and the second one is the suspensory theory of strike. Now, if all of these are done, the government may resort to the suspensory theory of strike. When you now resort to the suspensory theory of strike, the salaries, wages, emoluments, entitlement are stopped.
Okay.
Thank you. Point it stops.
Thank you for throwing light in this direction. Well, in case you're just joining us, it's Law and You, and we are on the topic, the ASUU strike, looking at the federal government no work, no pay policy, the legal implication of this, and that's where the legal practitioner, Sunday Daudu, comes in. Let's look at this aspect, where the lecturers, or the union, through its national president, Emmanuel Ashodoke, recently said that if the federal government does not pay the outstanding arrears, they will not process the 2 sets of admission of students, before them. Do they have the right to say that?
Let me.
Is that not an open threat to the federal government?
No,
how does the law see that?
Strike itself is a threat.
Oh.
The court has said it. That strike is a threat to compel government to do what they're supposed to do. Now, let me tell you, sir. If you look at, let me just refer you to Section 9, Subsection 6 of the Labor Act 2004. That provisions prohibits government or forbids government or any employer from victimizing an employee for engaging in trade union activities, including strike. So if you stop the salary of workers while trying to enforce a collective agreement, you are victimizing them, which that section forbids. And that act is an act of the National Assembly.
But do you know that this whole argument can be on both sides? In the sense that we've seen where some lawyers argue that this aspect of no work, no pay rule is legal and could be binding, on the union. And here you are saying the otherwise.
I said there is a provision for Section 43 says so.
Okay.
It's legal.
Okay.
The no work, no pay rule is legal.
Okay, but when it's applied?
When is it applicable?
Okay.
When do you apply it?
Okay.
Is it when the government itself is in breach of implementing a law? Do you benefit from your own wrong?
So at present is not
you can't
legal.
Apply it now.
Okay.
If the government apply it, I'm saying the law says you are victimizing the lecturers from enforcing their right guaranteed under the Labor Act and guaranteed under the Constitution. Now, if you look at Section 34 of the 1999 Constitution, which is the first set origo of all laws, it provides that, or it prohibits against forced labor. Forced labor. Then what is forced labor? So that you understand all of these issues, so that people cannot just go out there and just be talking where they have not followed the sequences of actions. Forced labor is a situation where the government force or compel or tactfully forced a situation on workers to accept whatever they offer just for their mere survival. That is, the government say, I'm going to be paying you $1, whether you accept it or not, it's not. Okay, but is it not possible, as we round off on this point, is it not possible that even as it goes to a court or the tribunal, where the federal government's counsel and that of ASUU will have to produce intelligent reasonings, is that what you call it? Yes.
Yeah, now on why this should hold sway, why this should not hold sway. Is it not also possible that just as you are speaking on this side, that other lawyers will also speak, in favor of the federal government and saying that the no work, no pay rule can apply now?
No, it cannot apply because there are mechanisms for dispute resolution.
Which is not known which is not known to the other lawyers?
No, it's there in the law.
Okay, so
it's Structure says so.
So why are some also holding this opinion?
No, you see, there are persons.
Although it can be contested in court.
No, there are persons who do not understand the mechanism for dispute resolution.
Okay.
Their whole argument is that it's contained in the law that when there is no work, no pay rule. It's there. We are not saying that it's not there. But the Nigerian context,
the applicability.
Yeah, we operate what we call the Westminster's model.
Okay.
Of do it yourself. Let the both parties resolve their matters. And I told you the procedure. If all this procedure fails, the minister takes what we call apprehend. He apprehends the matter and refer it to either a conciliator, if a conciliator, a mediator for a conciliator, if a conciliator to the National Industrial Arbitration Tribunal. If he fails, he go to the Industrial Court, National Industrial Court, and the decision given there.
Okay, thank you so much. Big thanks for taking our time to be part of this discussion. Well, a lot has been said by the legal practitioner as it pertains to the no work, no pay rule or policy, when it applies, when it shouldn't apply. Well, we look towards the federal government and, of course, ASUU in putting all of these strikes to rest. We'll do this sometime next week. I'm Philip Omo Gupo. Goodbye.